This video talks about how to avoid a criminal conviction for a drug possession or supply case. So if you're charged with drug possession and or drug supply, there are ways for you to avoid a conviction by either getting the case dropped, that is withdrawn, or if you're going to plead guilty, of getting what's called a Section 10. Now Section 10 is when you plead guilty, but the magistrate or judge does not impose a criminal conviction upon you. So the first way to avoid a conviction is to try to have the case dropped. Now, if you're charged with drug possession, it may well be the case that you were searched by police, your body was searched by police, or your bag was searched by police first. Now, police can't just search you for any reason. They have to have a suspicion on reasonable grounds that you have drugs on you at that particular time. Now, often police will say, oh, it's a known drug area, and there's people supplying drugs in that area and so on and so forth, and you look nervous. That's not enough to ground a reasonable suspicion. They have to have some real reason to believe that you had drugs on you at that particular time. For example, if the drug sniffer dog sat next to you, or if they say that they saw you exchanging money and a bag or something like that, they have to have some real reason. Now, if one of my senior lawyers reads through your police papers and believes that the search was illegal, we can write to the police and point that out, and we can ask for the case to be withdrawn. We can advise them that if it's not withdrawn, then once we win the case, we will ask for your legal costs. We'll ask police to pay your legal costs. So illegal search is one way to get a case dropped. Another way to get a case dropped is if drugs were found in a common area in your house, in a lounge room or somewhere that other people attended or other people could access, we can ask for the case to be dropped on the basis that they cannot prove what's called exclusive possession. It's another way to get the case dropped. Now, sometimes police will charge someone with supply and with possession. Now, there may be no issue that the person was in possession at that time, that the search was legal, but we can also ask them to drop a supply charge on the basis that you plead guilty to the possession charge. And really, you should never plead guilty to drug supply charge until you receive legal advice, because it may well be the case that your criminal lawyer can get that drug supply charge dropped, and once that drug supply charge is dropped and you plead guilty to the possession charge, you may be in a good position to avoid a criminal conviction. Now, if you are going to plead guilty to drug possession or even drug supply, there are some steps you can take to avoid a criminal conviction. The first is to consider doing what's called the merit program, magistrates early referral into treatment program. Now, merit's a program which unfortunately does run over 12 weeks, but if you do the merit program and get counselling and do what they ask of you, attend meetings and so on and so forth, or whatever they ask of you, undertake urinalysis and so on, and you finish it up to the 12 weeks, there's a good chance that the magistrate will deal with you very leniently, perhaps even with a Section 10. So doing the merit program is something that you can consider. Now, if it's small possession charge, so if you've got a few ecstasy tablets or something like that, then you may want to just plead guilty on the first available date and to have the matter sentenced on that date. Now, in the lead up to that first court date though, there are a couple of things that you can do to increase your chances of getting a Section 10, that is not getting a criminal conviction. First is obtaining up to 3 character references. So character references are letters from people who you know, your boss, your colleague, someone who's known you for a long period of time, that talk about you, your general character, and they must, however, say in there that they're aware that you're pleading guilty to drug possession or supply, if that may be the case. So getting character reference is important. You can get 1, you can get 2, but 3 is the best. So that will be handed up to the magistrate in court. The magistrate will read that. It will show that you've admitted these to those people who are close to you, and it can show that you are sorry for what you've done and you're unlikely to do it again. So getting character references is the second thing that you can consider doing if you want to plead guilty to drug possession or supply. Another thing that you can do is consider getting a good criminal lawyer. The reason for that is there's ways to get the magistrate or to persuade the magistrate to not record a conviction against you. How are those ways? Now, if you only possess a few ecstasy tablets or a small amount of speed or ice, whatever it might be, then your lawyer can make submissions. That means talk to the magistrate about the fact that it's very unfair that you should get a criminal conviction when someone who possesses cannabis so marijuana, avoids a criminal conviction. And there's particular case law about that. If someone possesses marijuana 15 grams or less, the police can give them what's called a cannabis caution. Now, the New South Wales Court of Criminal Appeal has said that all drugs are the same and they should be treated the same, all of these illegal drugs, right? So your lawyer can make submissions to the magistrate about it being very unfair that someone can be cautioned for possessing cannabis and that you, on the other hand, for a few ecstasy tablets or whatever it might be, will get a criminal conviction. And that can be a very, very powerful submission to make. So getting a good criminal lawyer who can help you prepare for your case and can make these submissions, that is, talk in court and persuade the magistrate to let you off, can be a good mix to avoiding a criminal conviction in a drug possession or supply case. A final thing that you might want to consider is a letter of apology to the court. So the letter of apology can be addressed to Your Honour. It can talk about the fact that this has been a very difficult experience for you, about the fact, however, that you understand that drugs have a very negative impact upon society, and that you buying drugs or dealing drugs or whatever it might be really has contributed to the black market in drug supply and all the negative things that go with it. So your letter of apology can talk about that. You can obviously apologise for what you've done. You can take responsibility for what you've done. You can talk about things that you've done to avoid using drugs again. Maybe you've done some counselling, or you might have done something else, some research into negative effects of drugs, or so on and so forth. You can talk about that, and it can help persuade the magistrate that you won't engage in drug possession or supply again. And it might get you a Section 10 in the end, which is the holy grail when you plead guilty to a drug possession charge. Good luck.